La Cour.
Morning. I declare open the public hearing in the case of Associations of Citizens RADKO and Paunkovski versus the former Yugoslav Republic of Macedonia. The case was lodged on 30th July 2001 with the court under Article 34 of the Convention by an Association of Citizens RADKO and by Mr. Vladimir Paunkovski, its chairman, who has Macedonian and Bulgarian citizenship. The application was communicated to the government on 3rd November 2005. The Macedonian government are represented by the agent Mrs. Radika Lazareska-Kerovska. The applicants are represented by Mr. Jonko Grozev, counsel, assisted by Natasha Dobreva, counsel. The second applicant, Mr. Vladimir Paunkovski, is also present. The Bulgarian government are represented by Ms. Svetla Atanasova. I welcome the representatives in the name of the court. Having consulted the agents of the governments and the representative of the applicants, I have determined the order of addresses as follows. Mrs. Radika Lazareska-Kerovska for the Macedonian government will speak first, Mr. Jonko Groziev for the applicants, and then Ms. Svetla Atanasova for the Bulgarian government. I call Mrs. Radika Lazareska-Kerovska for the Macedonian government.
Thank you for giving me the floor, Mr. President. My name is Radica Lazarevska-Gerovska, just to correct you. Honorable Mr. President, honorable judges of the European Court, it is an honor for me to represent the government of the Republic of Macedonia before the court. As to the specific case, the court submitted a set of questions grouped into 5 entities, so in the continuation of this presentation, the government shall provide answer to the same, with which we believe there will be conditions created for the court to make a decision in respect of the admissibility and the merits of the case. First of all, I would like to present to you the government's position regarding to the admissibility of this case raised before the court. In view of the first set of questions, the government of the Republic of Macedonia, so far on 2 occasions, that is in its written observations of February 2006 and in the additional observations of 2007 September, state it stands that not only have the applicants not exhausted all the domestic effective remedies available to them, but that they have also not tried to make use of any of the remedies that they could have used, both in view of the protection of the freedom of expression of thought and in view of the freedom of association. As time is precious, we would not like to reiterate the arguments for such claim on this occasion, but we shall recall only to the following. So far, the domestic courts in connection with the applicants have acted on 2 grounds only. Regular courts have acted regarding the entry of the association in the registry of Association of Citizens and the establishment of the termination of the association, while the Constitutional Court solely judged the acts for the foundation of the association on the basis of 3 initiatives for the appraisal of the constitutionality and legality of the same, submitted by 3 different submitters, none of them the applicants. We reiterate that in no moment whatsoever, before any state body, the applicants have not actualized the issue for the protection of the right to freedom of expression and association. The detailed reasons for such stance may be seen in the government's written observations previously mentioned. On this occasion, we shall recall to a few facts only. On 24th of May 2000, the Association adopted its acts, the program and the statute. On 19th of June 2000, the Basic Court in Ohrid entered the Association in the Registry of Association of Citizens. On 27th of October 2000, the promotion of the Association took place in Skopje, when the incidents with the smoke bombs and the beating up of one of the journalists attending the promotion of association occurred. In early November 2000, the Constitutional Court received the initiatives for the appraisal of the Associations Act and a request to annul the entry of the association. The association submitted the acts and the promotion speech upon a request of the Constitutional Court. On 26th of January 2001, the Constitutional Court passed resolution that a procedure for the appraisal of the constitutionality of the acts of the association would be initiated, but at the same time the initiative for the assessment of the resolution for an entry of the association in the registry was dismissed. On 21st of March 2001, with its decision, the Constitutional Court annulled the acts of the association. On 9th of January 2002, the Constitutional Court addressed the Ohrid Basic Court and returned the writs taken from the court, but also requested information about the possible measures taken for the purposes of enforcing the decision of the Constitutional Court. On 16 January 2002, with a resolution, the Ohrid Basic Court decided that the work of association be terminated. That resolution became final on 11 of February 2002. We shall conclude this list of facts with only one additional date. The application before the European Court was filed in July 2001, which means whole 6 months prior to the erasure of the association from the court registry. This means that at the moment of the filing, the application was premature, since the Association of Citizens still existed, was registered and functioned without any problems. The Basic Court in Ohrid, according to the fact noted above, allowed sufficient time period for the founders to harmonize their founding acts or to submit new acts, for the purposes of which it waited for whole 9 months to erase the association from the Registry of Association of Citizens. On this occasion, we would like to point that the rights guaranteed under Article 10 and 11 of the Convention are also rights guaranteed by the Constitution of the Republic of Macedonia, with Article 16 and with Article 20. Article 50 of the Constitution guarantees the right to every citizen to invoke the protection of freedoms and rights defined by the Constitution before the courts and before the Constitutional Court, in a procedure based upon the principles of priority and urgency. Given that the rights enshrined in Article 16 and 20 of the Constitution are among the fundamental citizen rights, in its Article 110, the Constitution of the Republic of Macedonia stipulated their protection by the Constitutional Court, which, as the highest form of court, enables direct protection only to a small part of constitutional guaranteed freedoms and rights, referring to the freedom of conviction, consciousness, thought, and public expression of thought, political association and activity, and prohibition of discrimination against citizens. The government believes that the European Court, from the so far communication with the government, and the applicants, it's quite clear that the Constitutional Court has not had an opportunity whatsoever to consider the right to freedom of association or the right to free expression of thought, which were for the first time actualized before the European Court for Human Rights itself. Given the case law of the European Court that the requirement of exhaustion of domestic remedies is satisfied where an applicant has raised before the national authorities, at least in substance and in compliance with the formal requirements, and time limits laid down in domestic law, the complaints he intends to make subsequently in Strasbourg, as well as the doubt of the applicant about the efficacy of the enumerated domestic remedies does not exempt him from the requirement to exhaust the same, the government suggests that the court find as undisputed the fact the direct and premature address of the applicants to the European Court for Human Rights makes the application absolutely inadmissible. Regarding the question on the effectiveness of the Constitutional Court complaint, the government points that it is very ungrateful to give an answer to what would happen if something would happen, namely, would a constitutional complaint be an effective remedy or not? It is a fact that the applicants completely ignored that possibility provided in the domestic legislation, the Constitution and the law. The Constitutional Court, as a body that was competent to see the rights guaranteed under the Constitution and the Convention, acted only upon 3 initiatives for the appraisal of the constitutionality of the acts of the association, submitted by 2 legal and 3 natural persons who challenged acts before the court. On this occasion, we recall again that in no moment whatsoever did the Constitutional Court decide on protection of the rights and freedoms of expression of thought of association, but it only judged the acts of the association. That from the aspect of the constitutional and legal restrictions, that the programs and activity of association may not be directed at the violent destruction of the constitutional order of the Republic and at inciting or calling upon or stirring up national, racial or religious hate or intolerance. What was assessed was the part of the objectives of the association and the use of name of RADKO as the name of the association, according to philosophy of whom the Macedonian ethnos has not existed in this area at all, but that it belongs to the Bulgarians from Macedonia and the like. At no moment the Constitutional Court, appraising the acts of the association, did not act from the aspect of freedom of expression of thought or freedom of association of Bulgarians in Macedonia. On this occasion, we would like to stress one more time that the fact in the Republic of Macedonia there are existing and functioning several associations of citizens who feel themselves as Bulgarians from Macedonia. They actively work, and for some of them, in its correspondence to the court of May 2008, the government enclosed extracts from the central registry containing data about some of those associations. All this with a view to convince the court that the application should not be viewed from the aspect of restriction of freedom of expression of thought and association for the citizens who feel themselves as Macedonian Bulgarians and wish an association of their own. Regarding the second set of questions, it is undisputed that the request for the protection of the right to freedom of association is under direct protection of the Constitutional Court, and we consider that sufficient arguments for such a claim have been noted previously, as well in the very text of the decision of the Constitutional Court, when it decided on grounds of the acts of the association. We reiterate that the acts of the association were annulled by the Constitutional Court, since it concluded that part of the stances of the founders of the association and the Association Acts, as well as the name of association, with their robust character and a negating attitude towards the Macedonian people, were found to be in a contradiction with the national interest of Macedonian state. The Constitutional Court concluded that the insinuation noted in the acts of those associations and the use of the name of Mikhailov, whose ideological followers were the founders of the association, were not directed at a small grouping in the state, but they were an insult for the entire Macedonian people whose originality was negated, and the state had an obligation to protect the national interests of the state and its integrity. In case a request for the protection of freedoms and rights guaranteed by the Constitution and the Convention had been submitted before the Constitutional Court, it is certain that the procedure before the Constitutional Court would be completely different, and thereby the outcome could be completely different. It is ungrateful to speak from today's perspective about something that should have been addressed 7 years ago. We could not prejudge what would happen. It is a fact that the procedure for the protection of freedoms and rights is a separate procedure which is conducted exclusively upon a request of the persons whose freedoms and rights have been allegedly violated, and in line with the rules of procedure of the Constitutional Court, and depending on the affected right, the decision may be positive or negative for the requesters. The rules of the procedure do not envisage that the Constitutional Court is bound by some of its previous decision in assessment of a concrete actualized right. Everything was at stake at the moment, and it is ungrateful to prejudge anything. Even more, since there is an option for the Constitutional Court, upon a submitted request by the applicants for the protection of rights and freedoms of the applicants, in the course of the handling, to impose some other dilemmas and questions, which could result in initiating some other procedure by the Constitutional Court, which may, upon its own initiative, decide on the constitutionality and legality of certain law, regulation, or other general act. This is not rare that the Constitutional Court often to instigate procedures for the appraisal of the laws upon its own initiative. In support of this stance, numerous decisions were already communicated to the Court. Thus, maybe the request for the protection of the applicant's rights and freedoms would have provoked the Constitutional Court to engage itself into appraising the legal regulation for the association of citizens and repealing or annulling certain provisions, which as a consequence would have the need for the further regulation or further specification of the legal condition for the association of citizens. However, all this is only hypothesis which in no case would wish to prejudge anything. The examples of the cases of the Constitutional Court whereby the Court decided on the request for initiation of a procedure for the protection of freedom of conviction, consciousness and thought, and certain articles on the law on defense were repealed due to their causal connection, have been submitted to the Court. However, taking into consideration the protection of the applicant's right, we emphasize that the Constitutional Court could not have instigated such a procedure on its own, but that an activity by the applicants was required, which undoubtedly did not happen. It is a fact that the Constitutional Court was deprived of the possibility to build its case law in respect of the request for the protection of the right to freedom of expression, of thought and association, not upon its own guilt, but for a simple reason that the applicants themselves decided so upon their own initiative. We reiterate that it is ungrateful to prejudge what would happen in a time distance of 7 years back. The government finds it impossible to comment on the prospects of a success, given that it is a possible procedure before the Constitutional Court, which in its composition at that time was completely different from the current one. It is undisputed that the Constitutional Court would have had to decide on such a request, and it cannot be commented on the outcome. Anyway, there would have been a stance of the Constitutional Court, and the Republic of Macedonia was deprived of that at the moment, but not by its own will. In view of the third question, the government first of all recalls that the association was not dissolved by the Constitutional Court. In its resolution for initiation of the procedure from the very beginning, the Court dismissed the initiative for the appraisal of the resolution with which the association was registered. The association was erased by the Basic Court Ohrid in line with Article 52 of the Law on Association of Citizens. What should not be ignored is the fact that the Ohrid Basic Court did not erase the association from the registry immediately, but left a time period of 9 months for the founders of the association to harmonize the acts in line with the decision of the Constitutional Court, and that only after the request for information by the Court regarding the execution of the decision of the Constitutional Court, it took steps to erase the association. Should the Court under dissolution consider that the decision of the Constitutional Court on the annulment of the acts, the government recalls that the detailed reason for the social need are presented in detail in the decision of the Constitutional Court. On this occasion, we'll only remind that the Constitutional Court had in front of itself the task of taking care of the protection of the originality of Macedonian people, namely, taking into consideration a preamble of the Constitution of the Republic of Macedonia, in which a starting point is the historical fact that Macedonia is constituted as a national state of the Macedonian people, and that each activity directed at negating its originality is actually directed at the violent destruction of the constitutional order in the Republic, at encouragement or stirring up national or religious hate, or intolerance at negating the free expression of the national belonging. This from the aspect of the name and the objective of the association, as well as RADKO's teaching that the Macedonian ethnos has not never existed in this area, but the same belong to the Bulgarians from Macedonia, and that with its recognition, the biggest crime in the Bolshevik headquarters during its existence was committed. According to his philosophy, the process of debulgarization of Macedonia, carried out violently after the Second World War, is Serb communist slavery, and the Serb communist doctrine has continued to be an official doctrine in the state even after the independence of the Republic of Macedonia in 1991. Therefore, the Constitutional Court, having in front of it the acts of the association and also the promotion speech, where without any restraint the objectives of the association were presented and explained in more detail, found that the program and the statute of the association, viewed from the aspect of the prohibition defined in Article 20, paragraph 3 of the Constitution, should be qualified as a program objectives directly and explicitly calling upon destruction of the constitutional order, that is, expressly stimulating the stirring up of a national hate and intolerance, as well as determination and activities objectively meaning to be directed at what the Constitution does not allow. In order to answer the fourth question, the government again refers to the decision of the Constitutional Court, where the acts of the association were appraised. First of all, from the aspect of the goals of the association, with a special review on the affirmation of the Macedonian liberation movement and the use of the name of RADKO as the name of association, and all that from the aspect of his philosophy and practice presented in the observations of the government with a special review on the historical facts in them, the affirmation of the ideas of the Macedonian liberation movement according to the association as a matter of fact means liberation from Macedonianism as a Serb communist doctrine and from the invented Macedonian nation, which was used as an open gate for the entry of Macedonia within the frameworks of Yugoslavia. Therefore, the court judged that the statute and the program of association of citizens were directed at violent destruction of the constitutional order of the Republic of Macedonia and stirring up a national or religious hate or intolerance, as a result of which it found that the same were not in agreement with the Constitution. Finally, providing the answer to the fifth question, the government would like to clarify that in order to understand the stance of the Constitutional Court, that the acts of the association are directed at violent destruction of the constitutional order, one should bear in mind the wholeness of the act and not certain items or signs therein. The stance of the Constitutional Court regarding the affirmation of the ideas of the Macedonian liberation movement and the use of name of RADKO as the name of association had already been noted above. In its decision, the Constitutional Court did not engage itself at all in assessing the other goals of the association, and in no case did it find any objection to them. This even more since in the Republic of Macedonia nobody negates the fact that there are citizens who feel themselves as Bulgarians, and that nobody denies their right to association. We already mentioned that their association have existed and have been actively functioning for years now. What is also not to be ignored is the physical violence that occurred at the promotion of the association, that is the two violent incidents with throwing on the smoke grenades and the beating up of one of the present journalists, and for which the court was informed in the observation of 2007. From this it arises that, in order to understand the essence of the problem, the European Court should analyze the historical aspects of the case, for which the government has made an attempt to give a short review in its so far observations. The government is convinced that if the founders of the association had really wished to realize the other goals of the association, they could have done that very simply and could have harmonized their founding acts in line with the decision of the Constitutional Court. However, it is apparent that there is some other goal and reason behind the failure of the founders to act, which after the expiration of 9 months from the decision resulted in erasure of the association from the Registry of Association of Citizens and their direct address to the European Court of Human Rights, thereby passing over the entire domestic system for their protection. Those were the answers of the questions put by the court, and I'll use my right to add the government submission in another 10 minutes. Thank you.
I call Mr. Grosjev.
Thank you, Mr. President. Mr. President, members of this court, in this hearing I represent the applicants, the Association of Citizens RADKO, and the second applicant, Mr. Vladimir Paunkovski. The applicants welcome this opportunity to address the court and present their case. It is a case of particular importance for Mr. Paunkovski and all the members of the association, as it touches upon basic beliefs they hold. In these pleadings, I would like to focus on 3 issues, which in the applicant's view are crucial for the court's understanding of the case, and eventually for the court to reach a fair decision. which would be in line with its established case law. These issues are the following. First, I will address the grounds on which the applicant association was banned and the proportionality of the decision to ban the applicant association. Second, I will consider the interference with the applicant's rights, and more specifically with the second applicant's freedom of expression rights, because we argue that aside from the ban of the association, the applicants suffered further limitation to their rights of expression. And finally, I will comment on the available domestic remedies and their exhaustion by the applicants in accordance with Article 35 of the Convention. I will address the admissibility issues last, as in the applicant's view, these should be considered in the light of the substantive issues in this case. Before doing this, however, as this is a hearing both on the admissibility and merits, I would shortly review the facts which, in the applicant's view, are of crucial importance for the proper evaluation of the case. The summary of the facts is as follows. On May 24, 2000, 10 Macedonian nationals, including the second applicant, founded the applicant association in the city of Ohrid. In June 2000, the Ohrid Court of First Instance registered the association in the Register of Associations of Citizens and Foundations under the name Association of Citizens RADKO, Ohrid. The association had the following objectives: to raise and affirm the Macedonian cultural space, establish the traditional ethnic and human values, popularize the objectives, tasks, and ideas of the Macedonian liberation movement, and it was to achieve those goals through publications of its own newspaper, other publishing activities, establishing a library, electronic media, and other forms of cultural action. The association had taken its name, for its name, the most popular and frequently used pseudonym of Mr. Ivan Mikhailov, namely RADKO, to symbolize its link with the historic Macedonian liberation movement. The crucial objective of the association, stated on its behalf on other occasions, was to raise and affirm the Macedonian cultural space, the cultural and historical identity of Slavs from Macedonia who have appeared as Bulgarians throughout the centuries. It was precisely this goal that provoked high controversy and eventually led to the banning of the organization. On October 27, 2000, the association was officially launched. The launching took place in Skopje, where about 150 followers and the media were invited and were present. And after the opening speech of the chairman of the association, 3 young men threw gas bombs in the conference hall. That caused disturbances and a clash between 2 individuals, one of them a member of the association, and a retired journalist who apparently has facilitated the attack by the young man and who, as a result of this clash, was injured. The 2 individuals were convicted for that assault and they were sentenced 3 months imprisonment. The 3 young men who disrupted the event and caused the subsequent clash, however, received positive media coverage for their actions and were never investigated or charged with any offense. There was a strong media campaign both before the launching of the organization and after the launch of the association, which condemned its members and its functioning as contrary to the Macedonian national identity. The association was described as fascist and as rehabilitating the terrorism and fascism which were the basic characteristics of Hitler's collaborator, Vancho Mikhailov. The President of the Republic of Macedonia, Mr. Boris Paunkovski, officially stated that in the Republic of Macedonia, I quote, "There is no place for someone who claims that Macedonians are ethnic Bulgarians." Shortly before the launching event, the constitutionality of the association was challenged before the Constitutional Court, and on March 21st, 2001, the Constitutional Court declared the association's articles and program null and void as being directed towards the violent destruction of the constitutional order and incitement to national and religious hatred and intolerance. Later, April 2001, the decision of the Constitutional Court was published according to the constitution of the former Yugoslav Republic of Macedonia. It became final and enforceable after it was published in the official Gazette. And with the decision of the Basic Occrit Court of 11 February 2002, as was already mentioned earlier, 9 months later, the applicant association was terminated, a decision that was later confirmed on appeal by the Bitola Court of Appeal. As a result of all these events, the applicant association ceased to exist, and its members and the second applicant were prevented from promoting their ideas, both through the association, as it was banned, and more generally, because of the very hostile climate that was created around it. The main question for this court now is what were the reasons for the decision to ban the applicant association and prevent the applicant's activities. And with this question, I turn to the merits of the applicant's claim. Honorable judges, this is a case about the limits of freedom of expression. More precisely, this is a case about whether a state party to the convention could legitimately ban the dissemination of ideas related to national history, which it considers offensive to its national ideology and sense of national identity. The applicants argue that a state party to the convention could not do that, even if a majority of the population in a country finds such ideas offensive. And if a state party does that, does ban such ideas, this would be in blatant violation of its duties to protect and guarantee freedom of expression. The applicants do not dispute that certain ideas might well be banned by a state party to the convention, as they challenge the very essence of democratic government, or they represent a direct or indirect call to violence. This is the clearly established case law of this court and of many national courts in democratic countries. The applicants, however, have never even remotely suggested in the articles of the association of their organization or in their statements preceding or following the creation of the association any support or approval for ideas challenging the democratic principles of government or calling for use of violence. The members of the association do realize that their interpretation of history in the region is in marked difference from the official historiography in the country. Those differences and disagreements, however, are not about historic events and issues that touch upon the principles of democratic government, or which could be considered to be explicitly or implicitly promoting ideas of denunciation of the rights of others. A state party should protect citizens in expressing their rights. A state party cannot protect one account of history, even if it is crucial for the national identity of the country, by banning other alternative accounts of history. This is something, if it does, would clearly run contrary to the most basic principles of freedom of expression and freedom of association under the Convention. The fundamental opposition of the Macedonian authorities to the ideas promoted by the applicants were clear from the very start, and most clearly summarized by the President, Mr. Paunkovski, who stated that in the Republic of Macedonia there is no place for someone who claims that Macedonians are ethnic Bulgarians. The same line of reasoning was espoused by the Constitutional Court in its judgment banning the association, where it stated that, according to Ivan Mihailov's RADKO's teaching, Macedonian ethnicity never existed on this territory, but belonged to the Bulgarians from Macedonia, and that its recognition of Macedonian ethnicity, was the biggest crime of the Bolshevik headquarters committed during its existence. This is the heart of the dispute between the applicants and the official national ideology in Macedonia, and the one and only reason why the Applicants Association was banned and its members prevented from any public promotion of their ideas. But while the applicants' interpretation of the history of the region might be offensive to many, it clearly does not contain any elements of an attack against democratic rules of promotion of violent means. In all their statements, the applicants has always insisted on allowing every individual to take the decision for themselves what ethnicity they are. And this is a basic principle from which they have never stepped back. The government in its memorial so far, and in the oral presentation just made, characterized the applicants and the applicant association as promoting fascist ideas and glorifying the use of violence. This has been the accusation against the applicants before the constitutional proceedings, in the proceedings before the Constitutional Court, and in the submissions by the Macedonian government before this court. The applicants would like to state very clearly that those allegations of the Macedonian government claiming that the applicant association is fascist, is inciting national hatred and promoting violence and terrorism, are allegations which are not supported with any evidence. The applicants would like to underline the fact that no evidence was ever presented of activities and statements of the association and of its members prior or after the creation of the association that would support that allegation. These allegations are based on nothing but the deep aversion to the ideas promoted by the applicants and the desire to justify the censorship imposed on them. This is clear from the very reasoning of the Constitutional Court, which characterized the ideas promoted by the applicants, namely of Bulgarian ethnic origin of the Macedonians, as something that would mean a denunciation, I quote, of its tradition and culture. The Constitutional Court continued by saying that, I quote, the affirmation of the ideas of the Macedonian liberation movement, according to the association, in fact means rejection of Macedonianism as a Serb communist doctrine and of an imagined Macedonian nation, end of quote. In its judgment, the Constitutional Court made a direct link between the constitutional order and the official interpretation of history, concluding that any challenge against the official interpretation of history is a challenge against the constitutional order. It based its judgment on the reasoning that the ideas promoted by the applicants, I quote, must be interpreted as aims which directly and explicitly call for destruction of the constitutional order, that is, explicitly encourage an incitement to national hatred and intolerance. And then the court continues saying that taking the historical fact that Macedonia is constituted as a nation-state of the Macedonian people, and that every activity directed towards denunciation of its identity is in fact directed towards violent destruction of the constitutional order of the Republic and towards encouragement or incitement to national or religious hatred or intolerance, end of quote. The applicants strongly disagree with that logic, according to which one account of history challenging an official ideology is directly equated to incitement of hatred and violence. Such logic flies in the face of common sense. The adoption of such logic would simply mean the end of free exchange of ideas in a democratic society, as this court has defined in so many of its judgments. The government's repeated claims that the applicants are promoting fascist ideas, violence and terrorism, were also based on the claim that the person after whom the association was named, Mr. Ivan Mikhailov, was fascist and terrorist. The applicants dispute that claim too. A reliable historical account on the work and life of Mr. Ivan Mikhailov could not properly be the subject of the present case, as it is a matter for professional historians to discuss. What matters for the present case, however, is that by no means could Ivan Mikhailov and the Macedonian liberation movement, which he was leading for many years, be directly equated to support for terrorism and denial of democracy. Such a claim would be far-fetched and would have no evidence in historical accounts. The Macedonian liberation movement was started initially as a national liberation movement at the times of the Ottoman Empire, and Ivan Mikhailov became leader at a later point. The heyday of his leadership was in the early 20th century, and any account of his activities should take into account the significant political differences between our days and his time. In his activities, he was an ardent opponent of the political influence of the communist parties, the Communist International, and Serbia in the political life of Macedonia. What is of particular importance for the present case are the main ideas influencing his political activities, which the applicants sympathize with. The political methods and alliances Ivan Mikhailov made in his times are something that should be judged in the context of those times, and with which the applicants do not necessarily agree and never expressed any support for. The views and ideas with which they do agree are the historical account that a large part of the Macedonian population was of Bulgarian ethnic origin, and as a result of the policies of the Communist International and the policies of neighboring countries, and later the communist authorities started a process, a state-driven process of change of ethnicity. However, even holding that account of historic events, I would like one more time to underline and stress very clearly that in no way the applicants have suggested or argued that individuals are not free to define for themselves their national identity and their ethnicity. This has been a stable principle in all their statements and activities. No matter whether one agrees or disagrees with this historical account, it clearly does not imply any hostility to democracy and the rights of others. The last argument in support of the ban of the applicant association was that the applicant's view might provoke very hostile reactions by certain segments of the public in Macedonia. Even statements that might appear shocking and unacceptable to the authorities or the majority of the population, however, are protected under Articles 10 and 11 of the Convention. Freedom of expression would be meaningless if only views that are accepted favorably by everyone in society were protected speech. The applicants further argue that the views related to and aimed at the protection of basic rights of ethnic groups and their cultural and political identity, such as the applicants' views, are of paramount importance in a democratic society and should be provided enhanced protection. Even if such views might be shocking and disturbing for segments of the public, that could by no means be a valid ground for a prohibition of the dissemination of such views. Governments should focus their resources on challenging actual violence and certainly not on banning protected speech. In conclusion, the applicants assert that the association's dissolution was not necessary in a democratic society, as it was a democratic organization and had nothing in its program and the history of its leaders or members that could be interpreted as even a vague hostility to democracy and propagation of violence. I will now turn to the limitation of freedom of speech of the members of the association and their association, freedom of association rights. The applicants argue that both the second applicant as chairman of the association and all other founding members of the organization, along with him, suffered a limitation of their ability to exercise their freedom of association and freedom of speech rights as a result of the judgment of the Constitutional Court. The association ceased to exist, and the founding members of the organization, among them the second applicant, no longer had the opportunity to use the organization as a platform for achieving their goals. These goals were fully legitimate. The second applicant further argues that the specific circumstances of his case, namely the arguments developed by the Constitutional Court and the accompanying actions of the Macedonian authorities and the media coverage they received, further limited his expression rights. Not only his rights with respect to associating with others in pursuit of common goals, but also his right to freedom of expression, as such actions made it practically impossible for him to express his views and opinions in public. Since the creation of the association and the public announcement of its views and intended activities, he has been constantly harassed, and his public activities and his freedom of expression have been practically made impossible. The judgment of the Constitutional Court, and in particular the reasons it developed in support of its findings, that the bylaws of the applicant association were unlawful, were a major factor in this development. It created a public understanding that the association and its members were fascist, terrorist, and made organizing any public events or access to the media impossible. The second applicant claims that these actions of the official authorities have made possible that hate campaign. One of that action has been also the refusal of the authorities to investigate and prosecute the individuals who disrupted the launching event of the association. I will now turn to the exhaustion of available remedies. This is an issue that the Macedonian government argued at length, both in its written submission and today at the present hearing. The argument is that the applicant's complaint of violation of Article 11 and 10 of the Convention should be declared admissible for failure to exhaust domestic remedies. The government argues, more specifically, that an available domestic remedy was not used, namely an appeal of a violation of the applicant's freedom of expression and freedom of association rights to the Constitutional Court itself, in accordance with Article 10 of the Constitution of the former Yugoslav Republic of Macedonia. The government argued that as a result of the failure of the applicants to file a complaint under this procedure, the Constitutional Court did not have an opportunity at all to consider the right to freedom of association of the applicants. This claim of the responding government is simply not true. As it is quite evident from the judgment of the Constitutional Court, it did at length consider the freedom of association aspect of the case in declaring the association contrary to the Constitution. The interpretation of the Macedonian government of its domestic processes and procedures before the Constitutional Court wants us to believe that the Constitutional Court of the former Republic of Yugoslavia, Yugoslav Republic of Macedonia, is something like a lottery. You try once, you fail, try another time. You might be lucky. This process is plainly disrespectful to the Constitutional Court of the Republic of Macedonia. The Constitutional Court did discuss at length the reasons for banning the applicant association and their freedom of association rights. The Constitutional Court held, and here I quote, "The Constitutional Court had taken into consideration that the freedom and the right to association and activity of citizens as part of human rights and freedoms is one of the fundamental values for the existence and development of the democratic relations and functionings of the government in the Republic of Macedonia." And then the Constitutional Court continued by saying, I quote again, "However, the Court finds that the freedom and right to association, organization and activity cannot be taken to approve all aims and the choices of means for their attainment." In fact, the analysis of freedom of association rights of the Constitutional Court in its judgment, declaring the association's article of association null and void, has been pretty detailed and lengthy. Article 35 of the Convention requires the exhaustion of such remedies, which relate to the alleged breaches of the Convention and at the same time can provide effective and sufficient redress. The main concern of the European Court of Human Rights in that respect has been that domestic remedies has always made that any complaint about a violation to the European Court must be made after appropriate domestic courts had been used and before which the remedies and the impunged decision which allegedly violated Convention rights has been heard by the domestic courts. The Court has also explicitly held that the object of the rule of exhaustion of domestic remedies is to allow the national authorities, and primarily the judicial authorities, to address the allegations made of violation of a Convention right and, where appropriate, to afford redress before that allegation is submitted to the European Court of Human Rights. Where there is doubt as to the availability or efficiency of a remedy, the Court has ruled that the burden of proving the existence of an available and sufficient domestic remedy lies upon the state invoking that rule. On the basis of such standards, the applicants have clearly exhausted the available domestic remedies in accordance with Article 35 of the Convention. In their observations in writing, submitted to the Macedonian Constitutional Court, the applicants raised arguments related to the association alleged promotion, support of fascist ideas, ethnic violence and terrorism. It is true that those proceedings were not initiated by the applicants, but the applicants did make their arguments before the Constitutional Court of Macedonia. The applicants unequivocally disputed all those allegations that they're promoting fascist ideas, ethnic violence and terrorism, referring to the official documents of the association and the statements of their leaders. the lack of any explicit or tacit support for violence and fascist ideologies in the activities of the association is the core argument as to the proportionality of the interference with the applicant's freedom of associations. The existence of evidence in support of such allegations, and as a consequence, the legitimate aim behind the interference, were argued not only by the applicants, but also were the essence of the three motions to the Constitutional Court of the Republic of Macedonia and the judgment of the Constitutional Court of the Republic of Macedonia itself. The Constitutional Court itself not only considered those issues, but explicitly discussed the freedom of association rights of the applicants. In light of all those facts, the applicants failed to see what new could the Macedonian Constitutional Court consider if a fresh appeal was lodged. The subject matter of that fresh appeal would be identical to the case already heard and decided by the court in its judgment of March 21, 2001. By raising all their arguments about the aims and purposes of the association in their observation to the Constitutional Court, the applicants have clearly given the highest domestic court an opportunity to consider the interference with their convention rights and its proportionality. The domestic courts, later, have accepted that as a matter of domestic law, the lower courts are bound by the judgment of the Constitutional Court, and further appeal to the regular courts would be meaningless. The domestic courts simply saw themselves as enforcing the judgment of the Constitutional Court of the Republic of Macedonia. And finally, the Macedonian government has failed to provide any evidence that such repetitive complaints to the Constitutional Court did ever take place. In fact, the government presented evidence that individual challenges of the constitutionality of laws adopted by the Macedonian Parliament could be raised to the Constitutional Court. However, there is no evidence that a decision of the Constitutional Court enforced by domestic courts has ever been challenged again by the Constitutional Court of the Republic. In conclusion, the applicants respectfully allege that the remedy indicated by the government was not and is not an available and effective remedy within the meaning of Article 35, Paragraph 1 of the Convention. Thank you for your attention.
Thank you very much, Mr. Grosev. I call Mrs. Atanasova for the Bulgarian government.
Thank you, Mr. Chairman, honorable members of the court. The Bulgarian government restates its position that the application of Mr. Paunkovski shall be considered admissible and that it is grounded and well-founded. The dissolution of the association RADKO, which chairman was Mr. Paunkovski, infringed on his right to freedom of expression as guaranteed by Article 10 and his right to freedom of association as guaranteed by Article 11 of the European Convention of Human Rights. An established standpoint in the European Court case law is the principle that freedom of expression constitutes one of the essential foundations of a democratic society, one of the basic conditions for its progress and for the development of every man. Therefore, interferences in its free exercise entail a violation of Article 10 if they do not fall within one of the exceptions provided for in paragraph 2. The right to freedom of expression is closely related to the right to freedom of association. In practice, the exercise of the right to freedom of association is inseparable from the dissemination and assertion of certain views and conceptions. As the court had ruled in Eslin, the protection of personal opinions secured by Article 10 is one of the objectives of freedom of peaceful assembly as enshrined in Article 11. The association articles of the dissolved RADKO state inter alia that the association endeavors to popularize its objectives, tasks and ideas through publication of its own newspapers, publishing activity, library, through its own electronic media, seminars, conferences, forums and other cultural forms of action. The association program envisages further that for the achievement of these objectives, the association will organize public forums with the participation of outstanding cultural and scientific workers from the country and abroad through its local committees. The second applicant, Mr. Paunkovski, being a chairman and a key member of the association, would have undoubtedly benefited by all the different possibilities to propagate his beliefs were the association given the chance to live. However, the dissolution of the organization deprived him, as well as the other members of the organization, of numerous means for addressing the public and, above all, of a venue for organized activity. In the light of the above, the second applicant had clearly been divested of his right to give without hindrance public expression of his beliefs. However, the exercise of the rights guaranteed by Articles 10 and 11 is not unfettered. The interference could be justified in strictly specified circumstances provided for in the second paragraph of both provisions. The Court had explained that the conditions set out in Article 11, paragraph 2 are identical to those laid down in Article 10, save the last sentence of Article 11.2, and uses every opportunity to stress that the exceptions from the freedoms safeguarded by the two provisions must be narrowly interpreted and the necessity for any restrictions must be convincingly established. The Constitutional Court of the former Yugoslav Republic of Macedonia had been approached to examine the conformity of the Articles of Association and the program of the organization headed by Mr. Paunkovski with the national constitution and had come to the conclusion that they were incompatible with its provisions. The Court's decision had been followed by an ex officio termination of the activity of RADKO by the Basic Court in Ohrid. The Macedonian Constitutional Court had found that there had been a well-founded doubt that the association statute and program had been directed at the violent destruction of the constitutional order of the Republic of Macedonia and incitement to national and religious hatred or intolerance. The Court had reached that conclusion only on the basis of the examination of the provisions of the Association's Acts. It should be underlined that its activity had never become a subject of scrutiny, probably because of the very short term of existence of the organization. The central argument put forward by the Constitutional Court for declaring the Association's article and program unconstitutional is grounded solely on the convictions which the founders of RADKO share, and more precisely in their adherence to the ideas of a historical figure, that of Ivan Mikhailov. A pile of historical documents had been presented by the Macedonian government in an attempt to prove that his beliefs and activities had been terrorist and even fascist. The assessment of Ivan Mikhailov's personality and activity made by the Macedonian government is arbitrary. His life and convictions belong to the very recent past. The fact that some participants or witnesses of the events in which Mikhailov was involved are still alive renders it difficult, if not impossible, the impartial appraisal of his historical role in the Balkans geopolitical arena. Objective evaluation of historical events is feasible only from a distance. In any case, the interpretations of historical facts and events are irrelevant. They could not obscure the main issue, that nothing in the acts of the association could be interpreted as incompatible with the principles of democracy. On the contrary, it is clearly stated in all its documents that it is an independent, non-political public organization which objectives, although not pleasing for the official authorities, shall be pursued through all accepted democratic standards and principles. There is no evidence whatsoever that any of the members of the association have called for the use of violence or for the rejection of democratic principles. No evidence exists that activists of the association have accomplished practical action which effectively have threatened the constitutionally established order of the country. The European Court had clearly stated in a series of decisions that freedom of expression is one of the essential foundations of the democratic society is applicable not only to information or ideas that are favorably received or regarded as inoffensive or as a matter of indifference, but also to those that offend, shock or disturb the state or any sector of the population. The fact that the applicant's conviction and the association's aims have been considered incompatible with the current political doctrine in Macedonia does not make them incompatible with the rules and principles of democracy. As the court had rightly pointed out, such are the demands of that pluralism, tolerance and broad-mindedness without which there is no democratic society. This means, amongst other things, that every formality, condition, restriction or penalty imposed in this sphere must be proportionate to the legitimate aim pursued. It is obvious from the facts of the case, as well as from the statements of the Macedonian government, that the only reason for termination of the association's activity and, consequently, for silencing its members, the second applicant, Mr. Paunkovski including, are their convictions and objectives, namely, to raise and affirm the Macedonian cultural space, to establish the traditional ethical and human values, to popularize the objectives, tasks and ideas of the Macedonian liberation movement through democratic means. From these objectives, the Macedonian Constitutional Court had inferred that the real goal of the organization was to promote the idea that the Macedonian ethnos never existed in this area, which made it decide that the acts were directed at violent destruction of the constitutional order of the Republic and at stirring up national hatred and intolerance. We should remember here that the European Court had pointed out that while it could not be ruled out that an organization's program might conceal objectives and intentions different from the ones proclaimed, it was for the national authorities to verify that it did not, by comparing the content of the program with the organization's actions and the position it defended. An essential factor to be taken into consideration is the question whether there has been a call for the use of violence, an uprising, or any other form of rejection of democratic principles. The association RADKO was never given the chance to take many actions before being dissolved. Its objectives were interpreted in a way which was vigorously opposed by the official political doctrine in Macedonia. This becomes even clearer in the light of the fact that the basic court in Ohrid, which initially registered the association, did not find any incompatibility between its acts and the Macedonian constitution. Following a wide media campaign, the views of the members of the association had been presented as uncomfortable and troublesome. Hence, the trouble had been avoided by terminating the association and silencing its members. Thus, one of the main principles of democracy had been violated. The principle that the country's problems should be resolved through dialogue without recourse to coercion, even when those problems are irksome. From this perspective, it is evident that the termination of the activity of the association RADKO had been radical and disproportionate to the objectives pursued. The limitation of the freedom of association, as well as the freedom of expression, had not been necessary in a democratic society, as no pressing social need had existed for the ban of the organization. The Bulgarian government, therefore, considers that the termination of the activity of the Association of Citizens RADKO had infringed the right of the second applicant, Mr. Vladimir Paunkovski, to freedom of expression guaranteed by Article 10 and his right to freedom of association safeguarded by Article 11 of the European Convention of Human Rights. Thank you for your attention.
Thank you very much. I now turn to my colleagues in order to hear whether any of them want to put questions to the parties. No, it seems not to be the case, so I think we can proceed with the second round. And I called Mrs. Gerovska for the Macedonian government.
Thank you, Mr. Chairman. Having in mind the government's answers to the questions given previously, The government considers that the application should be declared inadmissible under Article 17 of the Convention, which provides, "Nothing in the Convention may be interpreted as implying for the state, group or a person any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth therein, or at their limitation to a greater extent than is provided for in the Convention." The government considers that the applicants attempted to deflect Article 10 and 11 from its real purpose by using their rights to freedom of expression and association for ends which were contrary to the text and spirit of the Convention. Such ends, if admitted, would contribute to the destruction of the rights and freedoms guaranteed by the Convention. At the very last, in today's government submission, we suggest the Court that paragraphs 2 of Article 10 and 11 should be applied in the light of the obligation under Article 17. The government bases such claim on the following circumstances. Everyone is entitled to state what one feels. That is his right and his personal matter, and that right as such is also guaranteed under Article 10 of the European Convention. However, on the other hand, the imposing of personal determination of the founders of the first applicant, as well of the second applicant, by negating the identity of the entire Macedonian people, is an attempt for an organized terror against it, which more than apparent has nothing to do with the human rights and freedoms of thought. We already pointed that the threatened object of protection is the national interest of the Macedonian state and the identity of the Macedonian people, as a result of which the Constitutional Court found that the part of the contents of the statute and the program are directed at violent destruction of the constitutional order of the Republic of Macedonia and stirring up national or religious hate or intolerance. The government reiterates that the intention of the founders of the RADKO Association in such a modern reality to create an association, the aim of which was the very negation of Macedonian people and nation, that is, its originality and statehood, by using some quasi-scientific historical facts, has nothing to do with the right to freedom of association and expression of the citizens. On the contrary, the act leads to a kind of provocation for the Macedonian people and its dignity, and cannot but result in mutual national hate and unrest, against which the Republic of Macedonia, in line with Article 10, paragraph 2, and Article 11, paragraph 2 of the Convention, not only has the right, but is obliged to undertake restrictions and sanctions, which in any democratic society are necessary measures in the interest of the state security, territorial integrity, as well as for the reputation and rights of others. Namely, the case law of the European Court in cases of similar nature, although it must be pointed out that we failed to find a case in which it is disabled to register an association, the ideology of which negates the existence of a people in the state in which it seeks to register, defines that the determination of the width of the margins as to what national interest is and the necessity of the protecting the same is a matter of the state and national legislation. Having in mind this very stance of the Court, and on the other hand, the standpoint in view of the necessity of the undertaken measures, and that the identification of the object of protection as a result of which the state interfered may be crucial for the outcome of the case, the government reminds that in the concrete case, the Constitutional Court concluded that the insinuations noted in the acts of the association and the usage of the name of Mikhailov, whose ideological adherents are the founders of the association, are not directed toward a small grouping in the state, but are in offense to entire Macedonian people, the self-identity of which is negated. This is the basis for the government presenting the historical facts to assure the court that the concrete case is not about disabling the founders of the RADKO Association, and among them Mr. Paunkovski, to freely express their view about them, feeling like Macedonian Bulgarians, and to request their association. On the very basis of the aforementioned, as regards the application of Article 17, the governments relied on the Commission's case law and the Court's case law. The government pointed out that where the right to freedom of expression and association was relied on by applicants, infringed the very spirit of the Convention and the essential values of democracy, the Commission and the Court had always had recourse to Article 17 of the Convention, either directly or indirectly, in rejecting their arguments and declaring their applications inadmissible. The Court noted at the outset that it is not for it to rule on the constituent elements of the offences under domestic law, or denying crimes against humanity, publishing racially defamatory statements, or inciting to racial hate. It is in the first place for the national authorities, notably the courts, to interpret and apply domestic law. The Court's task is merely to review under Article 10 and 11 the decisions they delivered pursuant to their power of appreciation. In so doing, it must satisfy itself that the national authorities base their decision on an acceptable assessment of the relevant facts. Regarding freedom of expression and association, the Court reiterated that although in its case law has enshrined the overriding and essential nature of this freedom in a democratic society, it has also laid down the limits. The Court has held, among other things, that there is no doubt that there is a category of clearly established historical facts whose negation or revision would be removed from the protection of Article 17. Accordingly, the government considers that, in accordance with Article 17 of the Convention, the applicant cannot rely on the provisions of Article 10 and 11 of the Convention regarding the conventions for denying historical fact that there is a Macedonian nation, that there is a Macedonian state which is internationally recognized and accepted. Therefore, if the Court considers that there was interference over the applicant's right, the government states that those interferences were pursued for at least two legitimate aims provided for it in the Convention: in the interest of national security and the protection of reputation and rights of others. Given all that has been mentioned previously, as well as the stance of the government in its observations from February 2006, September 2007, and today's submissions, the government of the Republic of Macedonia reiterates its stance that the application is first of all inadmissible on two grounds: procedural, as it was premature and submitted contrary to the provisions in Article 35 of the Convention, and essential, as the application is an attempt to negate the existence, originality, and statehood of a people that considers itself to be Macedonian, which is deprivation of the rights and freedoms of the Macedonian people as a whole, that is a wider range, and that is in a contradiction with Article 17 of the Convention. Should the Court, nevertheless, engage into assessment of the foundation of the application, and finds that the annulment of the acts of the association in itself implies assessment for a possible violation of freedom of association, and assessment for the restriction of the rights guaranteed in Article 10 and 11 of the Convention, the government reiterates its stance that the restrictions have been made in line with the Macedonian constitution and law, and that in this concrete case there has been no violation of the right to free expression of thought, and the right to freedom of association, guaranteed in Articles 10 and 11 of the European Convention for Human Rights, by the Republic of Macedonia in view of both the first and the second applicants. Those were the government submissions. Thank you very much.
Mr. Grosjev, you have the floor for your final observations.
Thank you, Mr. President. I believe I covered all the major arguments the applicants wished to make before the court. I will take issue with just one statement made by the Macedonian government, the representative of the Macedonian government, namely that there is no case law of this court that covers those issues. I beg to disagree. Not surprisingly, that case law comes from the same region, and there have been cases decided by this court. In one example would be Sideropoulos against Greece, another example would be Omoulinden versus Bulgaria, where the issue of free speech and freedom of association in the context of conflicting interpretations of history and national and ethnic identity has been decided by this court. What the Macedonian government wants us to believe is that definition of national identity should be treated as religion. It is true that this court has afforded religion a different status under the convention, and rightfully so. Attacks against religious beliefs and desecration of religious authorities are something that deserves better protection. Disputes about history and the building of national identity, however, are of a completely different order. They are part of the political process, and as such, they deserve to be given the robust space needed for a robust discussion within the public. And the court has clearly said so in those judgments which I mentioned earlier. As to the association and the fact that it was not allowed to exist and has not been able to demonstrate its intentions through its activities, I would just mention that the Association of Citizens RADKO sees itself as part and parcel of the Macedonian emigration, which has had organizations throughout Europe and Northern America, the United States and Canada, where it has been registered as a Macedonian Patriotic Organization. And there it has existed for many decades without anyone ever considering this to be a threat to democracy. This is all I wanted to add. Thank you for your attention.
Thank you very much. I finally give the floor to Mrs. Atanasova for the Bulgarian government, if you wish to add something.
Thank you, Mr. Chairman. The Bulgarian government will not avail itself of the opportunity to make additional pleadings. We reiterate our position that the application of Mr. Paunkovski is admissible, grounded and well-founded, and there indeed had been a violation of his rights guaranteed by Article 10 and Article 11 of the European Convention. Thank you.
Thank you very much. We have now come to the end of the hearing. I thank the parties for their interventions. The court will now deliberate on the admissibility. A decision on the case will be adopted later. I declare the hearing closed.